Welcome, Unica and Amara, to the Module 1 live session for the contracts course. This is going to be a very objective course where we're going to talk about the principles of contract law that you need to know to be a successful paralegal. Obviously you'll always be able to research the law, but with a basic understanding of contracts, you'll at least know what you're looking for when you start doing your legal research. So I'm Catherine Dove. I'm your instructor. It's an honor to be your instructor. When I was in law school, I actually won an American Jurisprudence Award in contracts. So contracts remains one of my favorite subjects to teach. And there's a lot of subtleties and nuances in contracts. But again, most of it's going to be very objective, Unica, unlike ethics where everything was subjective. Contracts, everything is much more objective, just based on, hard and fast rules and laws that we'll learn how to apply. So it's such a pleasure to have you here. This is my 23rd year of teaching, and I've learned a lot during those 23 years, and I've learned a lot from students in those years. And one of the things you learn when you get into academics is how much more there is to know, among other things. So it's always a pleasure to learn and work with students and learn about your experiences. So Amara, why don't you give us a brief introduction about yourself? I'm going to request that you unmute yourself. Amara. Do I have that right?
Yep, sorry about that. So I'm Amara. This is, I want to say my third quarter this year. I'm going to be graduating with my paralegal associate's degree next May. Fingers crossed soon. I am actually currently criminal defense paralegal for my public defender's office. Um,
Fascinating.
yeah, and criminal law is what I've always kind of wanted to go into, but I feel like after taking all these classes, I'm like, I don't know, actually, because learning a little bit more about every other, I guess, section of law that there is out there makes me want to explore a little more. But criminal law is definitely still something that keeps my attention.
Well, that's great because there'll never be a shortage of work ever in
Yeah,
the area,
yeah.
in any area of law. There'll never be a shortage of work. If things continue the way they've been going. So
Mhm.
going in, becoming a paralegal, going into the legal field is a great way to have job security.
Yeah, definitely. Yeah, and I guess the last thing I'll share is that I'm actually pregnant. So I'm due the end of this month, so I'm really excited to pop them out already.
Congratulations. And we always offer flexibility and the possibility of an incomplete grade or an extension, when your assignments are due when you're in labor. It
Sure.
has happened. So just let me know, if you need that extra
Sure.
time.
So, well, thank you.
You're welcome. Congratulations. So exciting. I had a student last term, I think they had 7 kids maybe. She had a lot of kids.
Oh, wow.
And she was still working a full-time job and going to school.
Oh gosh, I can't even imagine that.
Uh-huh.
Well, props
Great
to,
introduction.
yeah, thank you.
Okay, Unica, can you introduce yourself to the class one more time?
Yes, I am Unica Garrett. I've been enrolled for a year as of yesterday with Rasmussen. I am going for my associates in paralegal and I'll graduate March 19th. So really excited about that. And then oh yeah, I've always been interested in family law. I'm actually not even the slightest bit interested in criminal at all. I'm completely against it. It's so corrupt. Family law is corrupt too, but it's a whole nother level. So, but I want to do family law because that's what's close to my heart. And I actually have my own family custody case in Hennepin County, which of course everybody knows is the same county where George Floyd was murdered and all of that good stuff. So it's not a corrupt county. When all of that happened, literally no black Minnesotan was surprised because of the area and how bad that place is. So not, so what I want to do is bring awareness to not just what happens criminally in Hennepin County, but also on the family side of things where so many mothers are having their kids legally kidnapped from them. So I want to work to bring awareness to that. And so I want to be a family law attorney. Ultimate goal is to be a judge in Hennepin County so that I can actually make decisions that will impact families in a positive way. And it has to be Hennepin County because it is so corrupt. So that's what I'm doing right now. But I work currently at CVS, but I actually want to get my bachelor's. I want to take a break before I go to law school, get my bachelor's in social work. So I am taking the steps to have that ready so I can start that on March 28th when I'm done here at March 19th. So that is what I am doing.
Great. And you have a wonderful plan and you have everything, set up and you know all the steps in your head. And I know a lot of people who, I know some people, I won't say a lot, who were attorneys and have become judges. So it can be done. So I'm so glad that you've chosen the path and you know exactly what you want to do. And this class will bring you one step closer, Unica, to achieving your goals. All right, let's get started. So we've had our introduction. We're going to look at a few things in Blackboard. We'll take a look at the Blue Book guidelines. We'll also take a look at the research tools that you'll be using this term. We're going to start out with the basic principle of what is a contract. A contract is a promise or a set of promises for which the breach the law gives a remedy or the performance of which the law recognizes as a duty. So a contract is a legally enforceable set of promises. Does not have to be in writing. Who are the parties to a contract? The offeror is the person who makes the offer, and the offeree is the person to whom the offer is made. So if I said to Unica, I offer you $100 for your contracts law textbook, I would be the offeror, Unica would be the offeree. The subject matter of that contract would be the textbook. There are 3 elements of a contract that must be met in order for a contract to be valid. There has to be an offer, which is an expression of an intent to be contractually bound to specific indefinite terms. There has to be a party that accepts that offer through an act or a promise, which indicates a willingness to be contractually bound. And then consideration is the third element, and that's something of legal value that's bargained for. Let me use an example we all know about, Netflix. So Netflix offers, what does Netflix offer, Unica? What does Netflix offer?
Oh, sorry, I didn't. Can you hear me now?
Yes.
Okay. Out of these 3 elements?
Just in general,
Or,
what is
oh,
it, what kind of service does Netflix offer?
streaming service.
Okay, good. You can watch your favorite TV shows or like probably any one of 100,000 movies. So Netflix offers a streaming service for entertainment. And if I accept that offer, um, then a contract is formed because there's something of legal value that's bargained for, and that's the streaming service that I'm bargaining for. Netflix is bargaining for my money. Money is valuable consideration. So the elements of a contract would be met if I subscribe to Netflix, click on all of the OKs and approvals and the agreements, and I subscribe to the Netflix service and I pay my monthly fee. That's a valid contract because there's been an offer and acceptance according to the same terms, and then a consideration, which is something of legal value that's bargained for. If you buy a computer on the internet at Best Buy, there's an offer to buy the computer that's been made by Best Buy, gives you the price, describes the computer. You accept that offer by, clicking the computer, putting it in your shopping cart, and then, clicking purchase at the end and paying for it. And then the consideration is the thing that's bargained for. You want the computer, Best Buy wants your money. So that'd be a valid contract. Contracts may be written or oral. The contract does not have to be in writing at all. A written contract would be easier to enforce, though, if you had to go to court. Let's talk about an oral contract. Anne talks to her next door neighbor, Bob's son, and asks him if he will mow her lawn for $20. Bob doesn't say anything, but he does put gas in the lawnmower. He pushes it over to Anne's house and starts mowing her lawn. Amara, has a contract been formed in this scenario?
Yes, but I had a question with oral contracts. Are
Mhm.
those more like unofficial contracts between the two parties? Or because I know, with written contracts, you can, officiate it and everything, but oral contracts, there's not any like, I guess, in the professional world that, are actually valid, right?
Now, oral contracts are perfectly valid.
Okay. So, but are they more like informal? Because I just feel like oral contracts, there's no, I guess there's like you can't really track them or anything. Whereas written contracts, there's written like conditions and stuff like that.
Forget what you've learned or what you've heard.
Okay.
Um, American law was brought over from England. It was adopted from the English system, the English common law. The common law says that you have a contract when there is an offer, acceptance, and consideration. And that's true in the business world. Sometimes businesses have supply and fill requirements, like gas stations, for example, would, routinely get gasoline or oil or petroleum from a certain company. And even if it's not in writing, they continue that contract for a certain period of time. Maybe Shell provides all the gas that a particular convenience store needs without knowledge of the exact amount that it's going to need, or even when that contract will end. That might be a requirements contract, or sometimes there's an outputs contract where, say, a wine distributor agrees to purchase all of the wine that a vineyard makes in a given year. There's not even a quantity known. It's just all that you make, I will purchase. Some of these contracts could be oral. They could be formed over the telephone, and it's perfectly valid because according to English common law, all you need to have a contract is offer, acceptance, and consideration. How would you prove an oral contract in court? That's why we have witnesses, testimony, and judges like Unica will one day be. The judge will hear the evidence, and the judge will look into the eyes of the witnesses and determine who is lying and who's telling the truth. So, testimony from a witness is as good as physical evidence, so long as the witness is credible. So if we were trying to prove an oral contract in court, you would simply have witnesses testify to what's happened. And, actions and conduct also support an inference of a contract. So no, a contract does not have to be in writing. Does that answer your question?
Yes.
Awesome. Okay, so getting back to our example of the oral contract, an oral contract was formed between Anne and Bob. A unilateral contract, that means there was one promise, and that promise was exchanged for performance. Anne promised to pay Bob $20 if he mowed her lawn. She wasn't looking for him to promise to mow it, she was waiting for him to mow her lawn. So that's exchanging a promise for performance. That's a unilateral contract. She made an offer that was valid with specific and definite terms. Bob could accept the offer. He could have promised to mow it tomorrow, or he could just start mowing the lawn. If he had promised to mow the lawn, that would be a bilateral contract because there'd be two promises. Any questions about how you create a contract or how you would create an oral contract? Okay. All right, so getting down to one of the elements of a contract offer. How do you make an offer? Well, an offer also requires three elements: a promise of future performance, a description of what each side gets, and a way to determine when each side has to perform. So when you're making an offer, you need to have specific and definite descriptions. So back to the example of Unica and I in the textbook, I offer Unica $100 for her contract textbook. Those are very specific and definite terms, and it's described. There's a promise of future performance in that if Unica gives me her textbook, I promise to give her $100. And then there's a way to determine when each side has to perform, and usually it's when it's reasonable. How do you enforce a contract? Well, if the offer is accepted, it immediately becomes a contract that's enforceable in a court of law. An example is a clothes washer purchased on a rent with an option to buy or rent to own plan. The seller has to deliver the washer described in the contract at the time of the parties entering into the contract. There cannot be any uncertainty as to which washer is being sold. The time of delivery should be specified and the dollar amount needs to be filled in. The exact times of payment need to be covered in the offer. An enforceable offer: price, consideration, and sufficient terms. Imagine Bill wants to be hired by Ron and June to paint their house. All of the terms are oral except for a brief unsigned bid that is not a complete sentence. Paint Ron and June siding on their house, $1,500 for labor, homeowners to pay for supplies to be completed this summer. The rest of the terms are oral and include information such as it is a workman-like job done in good faith. Bill is to scrape paint with a primer and finish coat. He must use the paint that Ron and June choose. Bill needs to bring his own ladder. So here we have an offer to paint a home. So your Module 1 assignment is going to require you to consider what a paralegal would do in a client interview about an oral contract. In your own words, figure out why an attorney might recommend that an oral contract be in writing, as Amara pointed out, when an oral one is just as valid and there are plenty of witnesses to the terms. So, Amara, why would it be a good idea to get a contract in writing?
Just so you can refer back to it and be like, no, this is the terms and conditions that we agreed on. Whereas if it was an oral one, I feel like you could say that and they would be like, no, and then everything would just be kind of hearsay at that point.
Exactly. Yes, it definitely makes it easier to enforce a written contract when you've got all the terms in black and white. So, if you were a paralegal, how would you go about interviewing a client to determine whether or not they have entered into a valid agreement to paint a house? What would you do? Let's suppose that Bill has been hired by Ron and June to paint the house, but June wasn't happy with the paint job that she received and she wants to sue Bill. What kind of things would you ask June about during the client interview, Amara?
I would, oh,
Or Unica? You can answer it.
I would ask if there were any contingencies that don't like the house, then there's no charge because that would be important. But if that wasn't there, then house should be paid for. The job should be paid for.
Okay. Based on what you know so far, was the oral agreement based on a complete offer or an incomplete offer? Is this a complete offer? All of the terms are oral except for a brief unsigned bid that's not a complete sentence. Paint Ron and June siding on their house, $1,500 for labor, homeowners to pay for supplies to be completed this summer. Is this a complete offer?
No, because didn't the homeowners I have to be like, okay, I agree to that?
That would be a contract. A contract requires offer, acceptance, and consideration. But we're only looking at the element of offer. The offer has to have specific, definite, and descriptive terms. All the terms have to be expressed in the offer. So, yeah, whether there's a valid contract is one question. We're wondering is this even an offer?
I mean, it seems to meet, I mean, just the unsigned part is kind of throwing me off, I guess.
Okay. So your module 1 written assignment is going to require you to look at this scenario. In your own words, why might an attorney recommend that an oral contract be put into writing, even when an oral one is valid and there are plenty of witnesses? Use the lesson notes. Comment on the transcript of the client's interview. How would you feel about the way the paralegal did the interview? How would you do the interview? If you were the interviewer, would you use a printed intake form and mark with handwriting? What other method might you use to make notes? Recommend 3 open-ended questions to ask client at a follow-up interview, and 2 questions asking for any documents that would evidence this agreement. Based on what you know so far, was the oral agreement based on a complete offer or incomplete offer? Argue both sides. So that's a great point. In the legal profession, as in life, as Unique and I were discussing earlier, when it comes to the vaccine or many other things, there's often not a clear right or wrong answer. There are arguments, facts that support more than one viewpoint. And in the law, we always need to be aware of the fact that there are both sides. Today, you might be a public defender. Tomorrow, you might be the prosecutor. Today, you might be defending the mother in the divorce case. Tomorrow, you might be defending the father in the divorce case. So you've always got to be prepared to see things from both sides and to see the arguments that are on both sides. So in this assignment, your conclusion is not as important as your reasoning and your citation to the law and other supporting case law and other theories and principles. Because there's more than one way to skin a cat. There's more than one way to resolve a problem. There's more than one way to view an issue. And in the legal profession, we've got to be able to see both sides, right? Because you want to know what your client is coming with you. What is your client getting ready to throw at you? You need to be able to see their side and what their arguments are to know what your client's getting ready to come at you with. And there's actually a moral obligation as a paralegal and as an attorney to go into court with unfavorable judicial precedents that go against your case. You have a professional responsibility of knowing and presenting to the court and opposing counsel unfavorable rules of law and cases that go against your case. So it's very important that you be able to argue and see that there are 2 sides to an issue. So this assignment is going to test you on that. You can always reach a conclusion, what you feel. Well, after analyzing this issue, I think that it was a complete offer and I think a valid contract was formed, but you're always going to have that because and the rationale and recognizing that there is another viewpoint, right, that has some validity. So for this module 1 written assignment, you have the option of using an application table to compare the incomplete and the complete offer and identify the characteristics of the complete offer. The table will help you apply facts of the assignment scenario to legal issues, facts, and cited authority. Quote and cite a portion of this week's lecture notes as authority. Your paper should be 3 to 5 pages in length with at least 3 references formatted according to the Blue Book standard. So we're going to talk about what the Blue Book is. It's a system of citations you'll be using the Indigo Blue Book, which is completely online. So let's go into the online classroom and take a look at some of the components of this assignment and some of the requirements of this assignment. Let's see here. Go into the classroom, doing that. Don't want that. Want to go share this web browser. There we go. Alrighty. And this is not the class that I want. I want home. See if I can get to the right term. Want to go back to the home page. Here we go. All right. Cool. Courses. We are in fall term 1. And we are looking at module 1, Introduction to Contract Law. We are looking at your first written assignment, which is due on Sunday at midnight Central Standard Time. And we want to see what it is. So the scenario again is about re-roofing a 1-story house. And then there's an application table, download application table. So you'll need to download this application table. Is anyone familiar with using the application table?
I'm not.
No, I've never heard of it.
Okay.
Yeah.
So it's a great way to do an issue rule analysis conclusion analysis. So I'm going to share this document with you so that you get familiar with it and it becomes your best friend. Okay, downloads. Application table, open. So one of the things we're going to learn this term is IRAC. It is a way of doing legal analysis. I stands for issue. The first thing you want to do is identify the issue in your case. The issue in this case is whether there is a valid offer and whether there's been a valid contract and what the terms are. So we need to know what the facts are that we're going to be applying, and we need to know what the rules are, and then we're going to make our analysis and conclusion. So here, this table has a place where you can enter in your facts. We know the fact is that there's Ron and June are the clients. They have a house. There's another fact is Leo. As a paralegal, you need to know the name of your client. You need to know the name of the person that you're suing, which in this case, we're representing Ron and June. We know what their address is and their phone number. They're suing Leo. We want to find out what his address is, his phone number, his company, Riverway Construction, what his company's address is, where it's located. The job he was hired to do was roof replacement. Are there any documents? We heard about a bid somewhere, a written bid. We want to know what documents are available. Can our client give us some documents about this roof replacement agreement? The lesson states that documents may be relevant to supplement an oral offer. Absolutely. The court can look at external documents, witness testimony to determine whether or not there was a valid offer. And then there was an oral bid based on a competitive written bid. What was the written bid? Which is a complete offer? Why or why not? And this last block in the table is your analysis and the application of the law to the facts. Here's what's said. In Module 1, the lesson states that a painter may make an oral bid and start work. This seems similar to this situation. So if it's similar to the roofing situation, the lesson would indicate that an oral bid to do a roofing job is an offer. It could be argued that the roof bid may not be as complete as the painting bid. So, you know, there's always an room for you to put in your argument and view both sides. Another issue is are the homeowners receiving a discount from the other contractor's bid? Do we need to ask any follow-up questions to the client? Leo said it was a discount from the entire price, but however, what's not clear is whether the roofing job includes the sidings, the soffits, the fascia. So that's the thing. If you say I offer to, you know, fix your roof, what does that offer include? What aspects of the roof get fixed? Or if I offer to paint your roof, well, what kind of paint? Is it a good paint? Is it bad paint? So there's more details that we need to know about. Were those clearly stated in the offer? Authority for using a writing, for citing, authority for using a writing that the parties have. Is there a case that says we can look at some external document to tell us whether there's been a valid offer or a valid contract? What follow-up questions should I ask? So this is a table to help you organize and analyze what facts you have, what facts you need, what the rules of law are, and what the issues are. So you can use this as like a worksheet, facts, questions, legal issues, cites, and you know your application analysis. Any questions?
Yes, I have a couple questions.
Yes.
So I'm a little confused because when I'm looking at under the instructions, under the part where the download application table, the second bullet point says to quote and cite a portion of this week's online lecture notes as authority and then copy and paste the table below your answers. I don't know what that means.
Okay, let me go back into the classroom and we'll take a look at the assignment again. There we go. Good thing I've gotten used to using WebEx. Go back and forth between all these screens. Course. So let's take a look at the assignment language, Unica. So it is saying, go ahead and populate. There we go. Use and complete the application table to compare incomplete and complete offers. Identify the characteristics of the complete offer. The partially completed table will help you apply facts of the assignment scenario to legal issues and cited authority from the reading. Quote and cite a portion of this week's online lecture notes as necessary. Copy and paste the table below your answer. So in addition to this table, you'll be submitting an essay that answers the questions also. Your paper should be 3 to 5 pages in length with at least 3 references formatted according to Blue Book standards. The purpose of the essay, Unica, is to answer these questions, these 4 questions. So you want to answer these questions in your essay, 3 to 5 page essay. So what was your question, is how to cite to the online lecture notes?
Yeah, I don't understand what that one sentence mean. Quote and cite a portion of this week's online lecture notes as authority. I
Awesome.
don't know what that.
Awesome. So going back to the ethics course, when we were in ethics, we had to cite to the textbook for a definition of duty-based ethics, right? Or utilitarianism, right? We cited to the textbook for that to get that information. Or Buddhism, right? Confucian ethics. Do you remember that, those terms? We would cite to the textbook. This is saying, look at your lecture notes and cite to your lecture notes for information about what an offer is. And if you don't see it in your lecture notes, cite to your textbook. Here we go. Offer. So here your lecture notes are under Module 1, Real Offer. An offer contains a complete legal description of what each side gets, right? It's a promise of future performance and a way to determine when each side has to perform. So as you are analyzing the scenario, you'll be looking at the issues, the rules, and where we get the rules are from our lecture notes. You can also get the rules from searching on Lexis Advance or in your textbook. Does that answer the question? So if you were, so here's how you would write this. In this case, we're trying to determine whether or not there was a complete offer to fix a roof. Well, the law says you have a complete offer when there is a promise of future performance, a description of what each side gets, and a way to determine when each side has to perform. The law says that's an offer. Now let me apply the law to this set of facts and reach a conclusion. So that's what you'll be doing in this assignment. And one way to get the law is to look in your lecture notes. You could also get the law by looking in your textbook. Course materials, and it's a wonderful textbook. E-text. So you will be citing to your textbook. You could also get on the web and search for cases where someone has made an offer to fix a roof to determine whether the court held that that was a valid offer or not. So when we do law, we're always looking at judicial precedents to determine, what the court has said in the past. So chapter 2 is about agreement. Chapter objectives define offer and acceptance. So you're trying to figure out whether or not our scenario presents an offer. Well, what's an offer anyway? We have to get a definition of an offer from the textbook or our lecture notes, right? Here's one from the textbook. The three elements are required for an offer. The offeror must objectively intend to be bound. The terms of the offer must be definite or reasonably certain. The offer must be communicated to the offeree. The process of reaching an agreement begins when one party makes an offer to the other party to sell or lease property or provide services. So that's your rule. You're going to analyze the facts of our case and then reach a conclusion. And you will need to cite to the textbook and cite to any cases that you need to use or the lecture notes. Does that answer the question?
Okay. Yes, partially. So when it says cite as authority, it's just citing, like just writing the reference.
Yes. And again, when you're doing legal analysis, as we did in ethics, You're analyzing a theory. Here it's a rule. In ethics, it was a theory. Aristotle's virtue ethics. Does this set of facts display ethics, yes or no? Here's the rule. The rule says you need to have a manifestation of a willingness to be contractually bound according to specific and definite terms that are communicated to the offeree. And you'll be determining whether this set of facts meets that legal standard of an offer. So you'll be applying the rule, the law of offer and acceptance, and the law of contracts, and you'll be citing to the rule and where you got the rule from, whether it be the lecture notes, the textbook, or if you do some research on your own. That makes sense? So your goal is to answer these questions. You can answer these questions, Unica, without the table. If you feel like you can do it without the table, that's fine. Let's take a look at the writing guide and the writing lab and some of our sources, okay? So you'll be writing a 3 to 5 page essay answering the questions. You'll need to use the Blue Book citation form. If you're citing to cases, that's how you would do it. If you're citing to ABA model rules of professional conduct, let's take a look at a sample paper. That always helps. Blue Book sample paper. Can you see this document?
Yep.
Perfect. So this is how a legal writing a brief might work. The first thing, notice the law has been identified. Under Federal Rule 56, summary judgment is proper when no genuine issue of material fact remains to be litigated and the moving party is entitled to judgment as a matter of law. The court must draw all reasonable inferences in favor of the non-moving party. It may not make any credibility issues. So the first thing we've done here is we have cited the law. Then we're going to go to our fact scenario and determine whether a summary judgment is available. Our facts show that Ms. Brown can prove a case of disability discrimination under the ADA and that defendant regarded him as disabled, he's otherwise qualified for the job, and that he's suffering an adverse employment action due to his disability. We've cited a case there for that definition of what it means to be disabled. There's your citation. Once Mr. Brown establishes his prima facie case under the ADA, the burden will shift to the defendant to offer a legitimate explanation for its actions. Again, citing to a case where that rule of law can be found. So, when you're doing law, there is some research to be done. And you'll be taking the facts of this case, doing some research to find out what the legal standard is, and then you'll be applying that to the set of facts to reach a conclusion, as opposed to just concluding something based on your gut feeling. Your conclusion will be based on the law. Notice throughout this document, the law is being cited, statutes are being cited, a law review articles being cited, etc. So I know this is new. I remember in law school, freaking out, realizing that I was going to have to learn how to do this legal writing. So we actually have weekly paralegal webinars to help break all of this down for you. You can attend a webinar that's going to show you how to do legal research. Let me know if you want to be set up with a meeting with the librarian to show you how to do research specifically on Lexis Advance. Here we go, webinar calendar. So it looks like Tuesday, there'll be a virtual tour of library and learning services. The 12th, there'll be APA basics. We've got more webinars for paralegal students. Let's get to paralegal sources. Okay, there we go, fast case. So one way that you can do research is to use fast case. Fast case includes primary law, cases, statutes. So again, throughout the course, we want to know, well, what is the law, Unica? You know, I'm dealing with an issue, for example, a mediated settlement agreement between two parties in a divorce. I need to know what the law is about settlement agreements when people get divorced. How would I find out? I would use a premier legal research service like Fastcase. You could also Google it. Google is a valid search engine for getting information. Fastcase is more of a boutique legal research service that you have to pay for. So if I wanted to know what the law, I want to see, let's see what the offer, acceptance, roofing, contracts, valid. So I got 3,497 hits. We'd want to narrow that down. Suppose I only want Minnesota cases. Here we go. Here's one from 2018. You always want to cite the most recent cases possible so that we know what the law is right now, not what it was in the last century or in the 21st century. So here's one. This might be right on point. Homeowner challenges the district court's grant of judgment to the contractor on a breach of contract case. Donald and appellant, their home and garage were damaged. They contracted with Red Cross Construction to repair the damage. There was an agreement. Parties executed a change order about the roof and siding material. Let me see if there is a definition of what it means to make an offer. So this is what you do when you do legal research. You use one of these, a search engine, and you try to find a case that's on point. Here we go. The formation of a contract requires communication of a specific and definite offer, acceptance, and consideration. As support for judgment, respondents submitted the written agreement regarding the repair to the home and garage, as well as 5 or 6 other documents regarding the agreement. They're trying to prove the terms of the agreement. There's several documents that have been cited. On this record, there's no genuine issue of material fact regarding the formation of a contract requiring to pay the contractor $1,000. So this is not really about an oral contract, though. So this is kind of how you do legal research. You're looking through this this premier legal research service provider Fastcase that you have access to see if there's a case that's already been decided that has the same facts of the scenario that we're faced with. Any questions? I know it seems like a lot at first. Does it seem like a lot?
Are we following the IRAC method? Is that, or is it just an essay aside from the table?
Following the IRAC method is recommended. Absolutely.
Okay, so if I formatted my essay that way, would that be okay?
That'd be great.
Okay.
And be clear on your issue. What is the issue? And when you talk about the paralegal and the interview, that may not lend itself well to the IRAC method. But certainly the issue of whether or not there is a valid oral contract is subject to an IRAC analysis. Was the oral agreement based on a complete or incomplete offer? Argue both sides. That should be IRAC. The other part, you might just write an essay based on your own words. Why might an attorney recommend that an oral contract be in writing? And there's stuff in the lecture notes about the benefits of putting an agreement in writing. If you were the interviewer, would you use a printed intake form? What other method might you use to take notes? Recommend 3 open-ended questions to ask the client in a follow-up interview. So those would just be essay style, but number 4 is where you're going to need the IRAC, Unica. The issue is whether or not there's been a complete offer. The rule is what the definition of an offer is. The analysis is how you apply the facts to that rule and what conclusion you come to, which is based on the rule, based on the facts, there either was or was not a valid offer to fix the roof. So, legal analysis is really is breaking down a problem, learning a format in which you can write about it, a standard way of analyzing things, a logical way of writing about it through IRAC, so forth. Again, you have the option of using the application table to compare incomplete and complete offers, identify characteristics of a complete offer. The table will help you apply the facts of the assignment scenario to the legal issues and the cited authority from the readings, quote and cite a portion of the lecture notes authority. Your paper should be 3 to 5 pages, double spaced, with at least 3 references formatted according to Blue Book standards. See the rubric for how your assignment will be graded. Any questions? I'm going to send you some information again about the paralegal legal writing and research workshops. I think there's one every week, and if you can't attend it, the meeting will be recorded. So I think that will help you along learning more about the resources that are out there and how to do legal research. So those seminars are available, and I'll be sure to distribute that information. Okay, so we'll be meeting each Wednesday at 6 p.m. for our weekly live session. There is not a live session question for this week. There will be for next week. Do you have any questions or concerns?
No questions. So will we get credit for attendance?
This week it's not going to be, there will not be a live session question for this week. There will be for next week though. So you will get credit for next week's live session. This week, your benefit is just because you were here, you got the information straight from the horse's mouth, so to speak. And students who attend the live session statistically get much higher grades. So, FaceTime always helps. And it certainly helps down the road when you need a letter of recommendation. And I remember Unica because she came to the live sessions and I know exactly who you are and I can write you a glowing letter of recommendation, as opposed to somebody who didn't come to the live session and I have no idea who they are. So this particular live session, there is not going to be a live session question, but there will be next week because that's just the way that the course is built. Good question, though. Any other
Awesome.
questions?
Thank you. I appreciate this live today. Thank you.
You're welcome. You're welcome. And thank you for coming. And I will see all of you next week. If you have any questions or concerns, feel free to call or send me an email. My e-door is always open to you. This assignment, again, is due Sunday at midnight Central Standard Time. Thank you, Amara. Thank you, Unica.
Thank you. Have a good night.
See you next week.